breakfast table today. The words like may is substituted by shall and shall is substituted by may, which makes a huge difference in the practicing level. It may not, substance-wise it may look the same, but when you try to implement a section, maybe the may and shall make a huge difference to us. And thankfully for us, or unfortunately for us, act, rules, clarifications, notifications, forms. These are the things we have got to study to be able to register a company law today, because what is not envisaged in rules is seen in the clarification. What is not given in clarification may pop up in the form as an additional field, which means we are going to do a lot of preparation for ourselves. So I would say that 2013, all our knowledge about Companies Act is gone. We have got to learn all about it again. That's the stage we are coming to, and therefore I would congratulate members for having organized this session, which is necessary for all of us. With this introduction, I would like to take the questions. Again, we are sticking ourselves to the questions that have been raised to us. If the facts of the case are slightly different, possibly answers could also may change. Therefore, in order to see that we are focused on the questions given to us, since the professionals have considered these questions are important for the audience, for the group to understand, let us stick to these questions. Anything over and above, maybe we have not had private level discussions only. The first question is talking about company XYZ Limited has two directors, namely A and B. A and B are also directors and shareholders of another company, WB, whatever. Both the companies have a business relationship for sale and purchase of goods. The business is in ordinary course as per the arm's length price. Whether both the companies are required to comply with provisions of 184 of the Act. Whether both the companies are also required to make entries in the Register of Contracts and AS 18. One what I would like to say as a practicing level is that we should not be irritated by RPT per se. Wherever disclosure is required, better we give the disclosure. That's much safer for us than questioning whether disclosure should be made or not kind of things. If an entry has to be made in the contract, even if it is not required, put it doesn't matter. How does it really matter to anybody? I think that's where conservative view should be taken. The answer to the question is 184 is applicable to private companies also. The language of the Act is any company. It's not talking about public limited company or so. Since company is the word used, I would say that 184 is applicable. And there is a hope of exemption to directors who are less than 2%, but in this case it doesn't appear to be so, and therefore exemptions are not possible. And we have to make entries in the Register of Contract and Section 189. There is no doubt about this. It's a fairly simple question to answer. I just put the 184. I don't think each one of you have got Companies Act. I don't want to go for this. The second one is a company has two shareholders, and these shareholders are only two directors in the company. Whether board resolution can be passed for the remuneration where there are only two directors and both are interested in related party, whether provisions of 188 will be given. There is one opinion that in such cases the resolution for remuneration should be passed in the shareholders committee, but again there are only two shareholders and they are directors. Interested shareholders will not be in a position to vote for the resolution. So what would be the way out? There is one provision 3 to the 188, which says, provide also nothing in sections are applied to any transaction entered into by the company which ordinary course of business, other than transactions which are not in arm's length business. I would believe, it's my personal opinion again, I would believe that remunerating of a director who is working for the company is an ordinary course of business, and therefore we should be able to avail the benefit of this particular provision in this case, and therefore we can take this route. And then it's since it's an ordinary course of business, maybe the two separate resolutions have been passed, resolution 1 for Mr. A, resolution for B, and when A is being passed, B will not vote. When A is passed, A is not voting. When B is passed, B is not voting. That's how we have to handle the situation, is my view. Yes.
Good morning. I will not go straight to the questions, but before that, just I want to compliment all the people who have sent their queries, as well as Hasmukh Bhai. They have raised such queries. I don't think even the law maker had thought that these queries could come. And it has been frankly a tough and challenging time, but I have done what I have to We are on page 76 of the textbook and I am dealing with question 13. Question 13 says essentially whether comfort letters and standby letters of credit issued by the holding company to the bankers of the subsidiary, whether those are covered by section 186, 185, 186, whether they are guarantees, and therefore they should be covered by 185, 186. The thing is that, as like Dr. Nasiman said, that each case would go on its merits in the sense that what is the wording of the letters of comfort and what is the exact wording of the standby letter of credit that is relevant. Each bank may have its own format, so we cannot say give a very generalized answer, but I am going by the what is the general concept of a letter of comfort and a standby, and how is it commercially understood. Now, guarantee has not been defined in the Act. So for that we may need to go to the Indian Contract Act section 126, which essentially says that it is a contract where one person agrees to perform the obligations of another or pay on behalf of another if that other person defaults. So you would have to read the contract and see whether because of that comfort letter or the standby letter of credit, are you taking an obligation that the subsidiary does not pay. Somewhere it would have been very clearly laid down. Generally, as a commercial concept of the document, letters of comfort are never intended to be a guarantee. They are supposed to be a comfort letter that okay, I know these people and they are good people, and they will, and if they don't, they will take some efforts to persuade them. That is a sort of depending upon each bank, that will be the wording. Standby letter of credit is intended to be a guarantee, and generally as a concept, it would be that the person who is issuing that standby letter of credit, he will say that I will pay if that person does not pay. Therefore, it is a guarantee. But with that, the wording of each agreement would have to be different. After that, is easier to say that if you are issuing to a bank, and the bank will give their format and they will say that this is where you will sign, you will not even change one letter, and sometimes they don't even give copies. But subject to that, as if you talk about concept, letter of comfort is not a guarantee, standby letter of credit is a guarantee. Next question is, I think, XYZ Limited, it has granted loans to following entities, section number 14. Whether section 86 would be invoked in the case of a wholly owned subsidiary, in case of a subsidiary, in case of a joint venture and associate. Section 186, unlike the corresponding section 372A, will come to some certain points in a later question, but as a rule, it is meant to cover all types of entities. So wholly owned subsidiary, joint venture, associate, these are all covered. Therefore, the loans given to them will be covered. The only exception is that in case of a wholly owned subsidiary, there is a exception given in Rule 11 for wholly owned subsidiaries and joint ventures, that you need not pass a special resolution if you are exceeding those 60% and 100% limits. But other than that, as a matter of principle, section 96 is that.
ABC has availed services from the related party around 50 crore, which is claimed to be an ordinary course of business and arm's length price. With the aforesaid transaction trigger the provisions of 188, further with the disclosure of such transaction will be required as per section 134 of the Act. Attention is drawn to AOC 2. Again, we have discussed about the third provision which talks about ordinary course of business arm's length. That I think we can avail the benefit of that particular exemption. But 134 disclosure has to be made. If you look at AOC 2, there are two parts to AOC 2. We have to fill up that part which talks about arm's length distance prices. So we have to fill up that part of that particular AOC 2. That's established. This is 188 is covering these 4-5 transactions is a good question. Allotment of shares related to KNP, licensing of a brand to other subsidiaries, corporate guarantee for a loan taken by an associate, appointment of CFO, receipt of reinvestment, etc. This again, analysis and application of section 188 onto these particular events. I have studied them. On the basis of my understanding, I say that allotment of shares to a relative of KNP, 188 is not applicable. Licensing of a brand to one of the subsidiaries, applicable to on 188C because it talks about the values and properties of some part, some form or the other. So brand is one kind of a asset of the company, therefore 188(1)(c) gets attracted. Corporate guarantee for a loan taken by associates by letter no in spirit possible if guarantee is invoked, property gets disposed of and attracts 188(1)(b). That's the real problem here. By to strictly interpret the law, it may appear that yes, it doesn't require 188, it does not get attracted to 188. But what if the guarantee is invoked? When the guarantee is invoked, assets of the company will go, and since assets of the company are getting involved into this, we have to apply 188(1)(b), and to the extent in spirit we may have to look at 188(1)(b) applicable. Appointment of CFO, deciding the remuneration, unless CFO is related, the provisions of 188 will not get attracted. If the professional is being appointed, that should be fine. Receipt of reimbursement of expenses on actual based subsidiary. Again, reimbursement of actual expenses is the word used, and therefore I believe they are in the ordinary course of business. If they are in the ordinary course of business, third provision to 188 will get kicked in, and to the extent that yes, we can take away the benefit of that exemption.
Next is question 15 for me, page 76. Whether loan given by a company to its employees will trigger the provisions of 186 of the Companies Act 2004. Which is number? 15. Question number 15 on page 76.
Page 76, question 15.
So the question is, whether loans given to its employees. Now this is, unfortunately and perhaps unintended or intended, we never know, probably unintended. But yes, the answer is yes, that 186 would apply to loans given to employees. So it can create problem, because it's not just a question of limits. Even if it has a limit, I don't think in the normal course of business any company would give loans more than 60% of its net worth. Maybe cumulatively yes. But even that you could always pass a special resolution, no shareholders are going to oppose. But the problem is charging of minimum interest. So that is going to hurt a little more, because many times you may want to give subsidized interest and all that. So all section 186 unfortunately would be applicable, yes. So it will be very difficult, but the answer is yes. Only thing is I want to give draw attention to a school of thought. And not that I agree with that, but many people have been adding. As you will see as we go further, there are many schools of thought on many things, and some widely varying different views are there. In this case, the argument is, you look at the wording of section 186, it says loan given to any person or any other body corporate. Now once you use the word any person, why do you need to go anything further? So when person includes company, individuals, anything, whatever is an entity under law is included. So why the word of any other body corporate? And why the use of the word other body corporate? The other body corporate, it would mean that it has to be something similar to the lending company. Or then person or any other body corporate, maybe you can take color from there and say that person should mean a corporate or any other body corporate, applying the principle of agis in generis, you try to paint this. In fact, you look at subsection 5 also. In subsection 5 of 186, it refers to only the borrowers who are corporates. And that the same words are being used in the rules. So school of thought is that, let us read down section 186 and say that it applies only to borrowers who are corporates. Now that I leave it to you. I personally don't agree with that view. That would be narrowing down the section too much. Better to ask for a legislative amendment and get certain exemption, let's say at least for employees. It makes sense. Because employees, for that there are already certain sections, like if you want to give loans to shareholders for buying of shares, there is a separate provision for that. There are limits for that. Now, if those limits are there and provisions are there, why do you need further section 186 approved? Why do you need to charge interest on that? But that is a matter of representation. Taking a view, of this side, and this has been aired many times. That's why I have to mention. Subject to that note, I would say the loans given to employees will trigger the provisions of 186. Next question is more interesting, and I believe it has been raised again and again. And part of this earlier section, people have been asking the speakers that what about deposits, and particularly what about deposits which were existing as on 31st March 2014. Coming to the specific question, is share application money which is existing as on 31st March 2014, is it deposits? So I'll give the answer to first and two. Specifically, what is the question has been raised, I'll give the specific answer. But then I give the answer to the point number 3, in question 16, which will color the answer a little bit earlier little. Is this deposits? No, it is not deposits. As on 31st March 2014, they were not deposits. 31st March 2014, the law applicable was the 1956 Act and the Company's Acceptance of Deposits Rules 1975. They clearly, excluded share application money without any ifs and buts. So that is excluded. Does the company have to issue shares and issue and allot shares within 60 days from 1st April 2014? Now again, this is where people have had certain views. In fact, I was surprised to see the Institute of Company Secretaries where they have said that yes, you should allot within 60 days. And if you allot, then you are very much in compliance. And if you don't allot, then there is a problem. Now the fact is, if you read the 2014 rules on companies on acceptance of deposits. Now first of all, this is subject to the fact that it is not deposits as on 31st March 2014. That subject to that, even if you say it talks of deposits accepted on or after 1st April 2014. In fact, section 73 also is a prospective section. It is applicable from 1st April 2014. So the deposits, anything which is received after 1st April 2014, that is what the law would apply. So if I receive, let's say on 1st May 2014, then I have to allot within 60 days. If I don't allot, I have to refund in 15 days, that you all know that. What about 31st March? 31st March 2014, that 60 days window is not there at all. So neither that limit is there, nor that eligibility is there. So there is no need or liability to refund or allot the shares within 60 days or 75 days. That is my view. So you don't have to issue and allot shares, within 60 days from 1st April. But as I said, Institute of Company Secretaries is one of those, and other people have also had this view. With due respect, I agree. And as doctors have said that there will be many views. I think we all have to just give our humble view, but we'll try to give reasons. Then you have to judge for what reason, what opinion you want to take.
If I can just add to this question was raised in several videos which I have attended, not as attended to LLP sessions where stalwarts in the field have spoken. Everybody has taken a view that events that have happened before 31st or 1st of April 2014, they don't attract the provisions of the new act. That's a very established point. For example, the next question I want to deal with is also talk about the same situation. Something happens before the 1st of April 2014, existing contractual liability, existing contractual arrangement, whatever it is, does it attract 2014 Act or 1st April 2014? It doesn't. It can stay put as it is. Only when renewal comes in, issues will be different. But as long as the existing arrangements continue, you can apply the old Act. That's the view taken by several stalwarts in the field.
Yeah. So the third, point in this is that the question raised is very in an interesting way. But I'll go in this particular case slightly beyond the question. Also, I'll of course answer that question. If the shares are not allotted within 60 days, can the company refund the money within 1 year, that is by 31st March 2015, without attracting any penalties? Now the question is, first of all, this is the 1 year window is given in section 74. The question is that does section 74 apply to past deposits? Now there are two views of thoughts in this. So when you say that refund of deposits, what is the meaning of deposits? Is the definition of deposits under the 1975 rules and 1956 Act will apply, or the new rules and new Act will apply? If you apply the new law, then yes, it will, it is a deposit, and if you have not allotted the shares within 60 days, then you should refund, and therefore 74 should apply. If you see that 74 has got a retrospective application. But you look at the consequences of section 74. If you do not comply, there is fine, there is imprisonment, there is whatnot. And there could be even further repercussions on the directors being eligible to continue as directors, and so the repercussions are very harsh. So the simple legal principle which you have all learned right from our institutes and college days is that when there is a very harsh consequences, you interpret that particular provision strictly. It may be as a practical sense, we may interpret it conservatively to advise our clients that you please may not take a chance. But other than that, that provision has to be applied strictly. You look at not just share application money, you look at other provisions. A good example, of course, is given of a share application money. You take an example of advance against orders. Advance against orders are now supposed to be fulfilled within 1 year. There are other similar time limits. Now, you can take a similar example that you have taken an advance against order on 1st February of somebody. Do you have to fulfill even that order within 1 year? That is also a question. Now let's just in this case very cleverly, maybe the the question he has not given the date. Now let me give 2 dates. Suppose the date of share application money was 1st January 2014. That is one situation. Another situation, it was 1st March 2014. If it was 1st January 2014, then 60 days got over last year only. So if you take that interpretation, that Section 74 should apply to past deposits also as defined in the 2014 Act, and 60 days had got over, they were deposits. But if you had taken on 1st March, then 60 days had not got over. So as on 31st March, they were not deposits, then how Section 74 apply? So there are so many other ifs and buts in Section 74. I think the intention of Section 74 was to give a window of 1 year to repay all past deposits, all those deposits, whether you have taken from relatives or directors and whatever which were exempt earlier, now they are included. I think probably that was the intention, but the way they have worded it, unfortunately, it is very bad, and I would take a view that although the question asked is, can I refund within 1 year and get away with the penalty? Yes, you have got 1 year to. But I would even go ahead and take a view that even 1 year is not required. Because there are so many difficulties. You might have taken all sorts of loans. You may not want to refund. You may not have the capacity to refund. So therefore you have to interpret the law. According to me, the law, the way it is framed, it is, there are enough ifs and buts there. And I don't think if, old deposits, if you do not repay, any penalties should require. But then, this is always, taking a strict view is one thing, advising a client what conservative and safe view is each of us will have to, go by.
Whether the provisions of 188 apply to contracts or arrangements between holding and subsidiary companies entered into 1213 for a period of 3 years. What actions are necessary for such continuing arrangement? Would it make a difference in this holding subsidiary? What would be the position of companies that are private companies? I think that there is an amendment to 188 as far as this holding subsidiary company relationships are concerned. The bill is already out, so we can read the bill, but it's not yet a law, so we can't take comfort under that law right now. But as of today, there is a provision in there is a clarification of July 17, 2014, which very clearly says that contracts entered into before commencement of the Act do not attract 188 till expiry of the original term. This is a departmental clarification. It's very clearly given, and therefore, safely 2012-13 contracts will continue for the 3 years of time. There is no doubt or confusion about it. Once the original period expires, then I think you have got to follow 188, provided whatever the amendment 188 is coming in a way which comes. SEBI has very clearly aligned. If you look at this October 17th clarification of SEBI, SEBI also aligned the RPT related law between listing regulations and Companies Act. They have aligned both of them to one another, and therefore whatever is applicable for under Companies Act is applicable for listed companies also. There is no doubt and question about it. And finally, 188 is applicable to all types of companies. I think the amendment that is coming up, I think may give exemption to private companies probably, but as of date, since both of them are, they are only talking about companies and not private or public companies, everything is applicable to private companies also. The next question is, Mr. A is a managing director of a private company. There are 2 directors of a private company, both are also shareholders of the company. How the private company will comply with the requirements of 186 for the appointment of managing director, whether the provisions of 184, 189 will apply, if yes, how the same will be complied with. There is no prohibition or appointment of shareholders managing director under section 196. If the question is applicability of 188, I would say that I would invoke the third provision, which will say ordinary course of business, I can do it, interested director may not vote. I didn't understand the question in the first sense of the term, because Mr. A is a managing director of a private company, there are 2 directors. I mean, the requirement of 196 is about payment of remuneration. Remuneration has to be paid to the managing director, so I don't find a big issue in this as such. And 184 is only talking about disclosures, therefore main disclosures. 183, if you look at 184.3, it talks about voidability of a contract in case of violation of 184. And in this case, company and managing director, both of them will be willing to continue the contract. So I would say that you better make a disclosure and leave it there. There is no much complication in this involved. And then I am giving the view on this, the entry into the contract under 189 as a very, very conservative view. I don't know, as audit professionals who may have different view, but as a company secretary, I would feel making an entry into the list of contracts should not be harmful to anybody as such. We are only complying with the right side of the law, unless they have got either taxation or audit-wise any issues. But I feel we should go ahead and do the entries into the contract, list of contracts.
Okay, we are on page 77 now. Whether loan taken from a person who is a shareholder and director will be exempt from the requirements of provisions of section 73 read with the relevant rules. Whether the loan will be treated as a loan from a shareholder or loan from director. This is an interesting question. A person who is only closely read the act would have raised this question. See, section 73, the scheme of provisions, if you see, that scheme is more or less the same. There is a deposit, there is a deposit definition which is there. And the definition of deposit, if you read with section 73, it says that whatever is excluded from the term deposit under the rules, they will get excluded. Now, once you receive a loan from a director, it goes out of the definition of deposit. So therefore, loan from a director is not a deposit. I mean, assuming you have taken a certificate from him and all that, but it is not a deposit. Once it is not a deposit, when you go to the next section which deals with deposit from shareholders, and then there is a procedure laid down, limits laid down for deposit from shareholders, it is not a deposit to start with. So if it is not a deposit to start with, merely because it is a loan from shareholder, the provisions relating to acceptance of deposit from shareholders would not apply, and therefore you need not comply with all that. It is like, I will give another example. You have taken a loan from another company. Loan from another companies are also excluded from the definition of deposits. Now, if that particular company happened to be also a shareholder, then it would not mean that that exemption goes away. The exemption still remains. So so that is again if you have a director and a relative and whatever, this exclusion always would override the other definitions in the 73 or else. The next question is again big controversy. Many people are giving different views, and but here I would advise even more question from my side. The question here is, as you know, section 185, 186, and probably 188. These three are the probably the most analyzed section along with maybe 73 and 74 because it is causing the maximum of frauds. Section 185, you all know, relates to loans to certain specified related parties, while 186 relates to loans, guarantees, acquisition of shares, etc. of other companies and other persons. The question which is essentially raised is if I comply with the provision of 186, or if I am not required to comply with the provisions of 186, do I also have to comply with the provisions of section 185? Like example, one example is given in the case of infrastructure companies. To infrastructure companies, there is an exemption under section 186. Now, if their infrastructure company wants to give loans, which to certain specified related parties, will the provisions of section 185 apply? In the sense that once an exclusion is made. So essentially the question is, do 185 and 186 exclude each other, or they exist at the simultaneously? Means they are overlapping and we go to comply with both. One of the reasons given in the question is, which is used by many councils, at least two councils I know of, saying that section 185 starts with the use of the word save as otherwise provided. Now, does that mean that if a provision has been covered by 186, then 185 will not apply? Essentially, that is the question, because save as otherwise provided, the argument here is that therefore save as otherwise provided, 186 providing something else, so 185 should not. I don't think this view can be possible under any circumstances. So here I will just try to be more strong, because in other places the law is ambiguous, so that can be more than 2 years, but it is US will taken. I cannot understand how these 3-4 words would negate section 185 altogether. If you go to see, practically negate, if you try to say that if I comply with 186, I should not be required to 185 and 186 operate in two different fields. Section 185 is, for example, giving loan to specified related parties. There is a particular purpose to that. It was there in section 295, the corresponding section. We also had section 186 in the form of section 372A. They always existed together, and there was never a question of that one overriding the other or one taking the other negatively. So I would not agree to the view, or rather I would answer the question that 185 is not excluded if 186 is complied with, or if 186 is exempted from. See, the words used are save as otherwise provided. These words are, I think, copied from section 295 itself, but section 295 used the word save as otherwise provided in subsection 2 of 295. Here there is no such word used, so maybe people are taking that, save as otherwise provided, we should take it 180. Save as otherwise provided, you take any court decisions, you apply any principles of rules of interpretation. We are meant to it is not a non-obstante clause. It says that if there is any other provision which specifically excludes, like 295(2) specifically excluded 295(1), in that case there were certain exemptions given, for example, private building. So it was said that these exemptions will apply to 295(1) itself. Here there is no clear cut. If suppose 186 said that notwithstanding anything given in that. So that I think also the way the question has been worded, it says that 186 allows giving of loans. Actually 186 does not allow giving of loans. It is your memorandum of association which gives the power to a company to give loans. 185 is just saying that if you give loans, then you comply with these provisions. So you cannot say that there is an enabling provision in 186 and therefore 185 should be overridden. So here the answer is that 185 and 186 operate in different provisions. 186, the compliance of 186 does not allow you to override 185.
Disqualification director, that is non-filing of return by company for 5 years, will have retrospective or prospective effect. The question is very treacherous, I would say. The question is, when are you trying to decide whether disqualification is applicable or not? It is today. When you take it today as a date of questioning the qualification, you have to go 5 years backward. Filing of returns was required now and earlier also. So question of saying that I wait for 5 years and they only examine this question doesn't arise. But on the date of question of whether a person is disqualified or not, we have to calculate the cutoff date, go backwards for 5 years and see. And therefore, you have to say that if there is not 5 years returns were not filed on the date of questioning, which is post April 1st, 2014, this disqualification will be attractive. The very question, retrospective, prospective, has no specific meaning in this particular context. It's a question of examining whether it's applicable or not. Next question is a very tough question for me to answer. If suppose some company has not filed returns and all the directors become disqualified, then how will the new board be constituted? Funny thing is that on the date of appointment, all directors become disqualified. Please read this question, very dangerous question. All the number of directors of the board are disqualified because of not filing of returns. They can't even appoint a new board because they can't operate as a board as such. So then, how does this company function and what will happen in this question was there very good question. No doubt the issue is very tricky. There is no alternative in the Act. That's what my understanding is. Because the Act does not have any provision whatsoever which says that I can appoint an administrator in case of failure of the board. There is no qualified board where the government can appoint an administrator to run the company. It's not provided in the Act anywhere, and therefore it's a very tricky situation to begin with. Therefore, we have got to look at appeal to MCA only. I don't think there is any answer to this question. But is the company worried at this point in time about this qualification, disqualification, or will there be a question of investigation here? If you go to MCA and say, all my directors are disqualified because I have not been filing return, it is very difficult to make an appeal to MCA also, because MCA will first say, why did you not file returns? So therefore I will investigate the affairs of your company. So I would request the practitioners to avoid this company as a client. You will get into lots of questions, and then auditors are also brought for, if there is a fraud in the company, auditors are questions first, not the company itself. And then who will take that? And then even then, okay, what is it you are trying to resurrect? In this company, it's okay, somebody will come as director at all. And is there a question? I am trying to give you all round answers, I understand this. This is a very tough question to answer. Strictly speaking, law does not answer this question. We have to go by appeals only to the respective authorities. But the grounds of appeal will be so difficult for us to make an appeal that we cannot even make an appeal there. This type of companies probably have to slowly dormant and dead. That's the best way of removing this company.
Any administrative review possible by any authority?
MCA we can go there. That's what I'm saying. You go to MCA saying that please provide me a solution. But what will MCA say? You say I want to do my graduation, I have not passed 10th class, give me relief.
We are question 19 now on page 78. Now, this and the next question is something which, our Institute of Chartered Accountants and, this is the way I would the organizers to look at, some of the wording. Because, the question is quite interesting, very clever. It may not have very far-reaching implication, but, it just shows that, how, poor the drafting is. This one and the next question. What the question which has been raised is, very cleverly raised, is that, I'll read out actually the question. ABC and Company is a reputed chartered accountancy firm. Now, one of the relatives of a partner holds security in the audited company XYZ Limited amounting to face value of 0.90 lakhs, that is 90,000 rupees. Can ABC and Company, that is a firm, be appointed as a statutory auditor of the company? Will the answer be same if the aforesaid relative holds the securities in an associate company of XYZ Limited? And attention is drawn to the relevant section and rules. So this is a very interesting question. Why I wanted to say is that who is really appointed as the auditor? That's where we have to go back to the fundamental, and this is where again the institute will need to clarify, because there are certain ambiguities here. Who is appointed? If I am an individual auditor, then I am appointed, I have to comply with, I should not hold shares, I should not be indebted, I should not have transaction, all those disqualifications I am personally. But if I am a firm, and now as we will see in one of the later questions, again, very interesting question is raised, now we will have firms where non-chartered accountants will also be partners. The section says that majority of them should be chartered firm, but then you could have company secretaries, you could have somebody else also. Who will have to comply? The third question is, if I am the signing auditor, if ABC and Company, I am the partner, I am signing, is the firm also liable to the same obligations of investing in shares, of holding, being indebted, of not having transactions? So there are three different situations that I see. One is the firm liable to this disqualification? Second is are all other partners also liable and their relatives? So signing partner is primarily liable, there is no doubt about it. The question is whether the other partners are also liable and whether the firm as a whole. So like in this particular question, of course the question is not raised, but this related question will come later on, but I just draw attention. Here the question is very simple. The firm has to be appointed, but a partner's relative is holding 90,000 shares. So now the way I read the section is, the appointment is qua a partner. If you read not only the section but also the exemption and the rules, the conditions apply to a person or his relative, and so on. So person or his relative, it means the individual, the signing partner. Because even the section says that if you appoint a firm, there has to be a signing partner. You cannot say that anybody is signing. There has to be a signing partner. So the question is that a partner's relative is holding shares of 90,000 rupees. Now, under 146(1)(3)(d) and relevant rules, up to 1 lakh rupees exemption is exempted if you hold shares of up to 1 lakh rupees face value. But there the words used are the person or his relative will hold. Now, let's read that section and rule also. It says that the person or his relative, first part of section 141(3)(d)(1) says that the person or his relative shall not hold shares in the company, this is important, in the company or associate company or subsidiary or holding, etc. So he should not hold the shares in the company, etc., etc., various companies. The proviso says that provided the rules may say that the particular person, the person or his relative may hold shares in the company up to a certain amount. So, and the amount specified is up to 1 lakh. Now the question is, how to interpret the company? The main part of the section says the company or its associates or its holding company or its subsidiary. The proviso says in the company. So I am allowed to hold shares in the company, the relative I am talking of, is allowed to hold shares in the company. The company has to be again used in the same sense as the main section is there. So the the anomalous situation would come is that I am allowed to hold shares up to 1 lakh in the company, but I cannot hold any shares in the associate, in the subsidiary, in the joint, and so on. Now you go to the next part. That is another provision which says that you cannot be indebted to the company or its associate or its holding subsidiary or its subsidiary company. So it says there also the words you use are in the company, holding company, etc., etc. Then the proviso that the rule says that you can hold indebtedness up to the specified amount there in the company, in the holding company, in the associate company, in the subsidiary company. You go further about guarantees. Again, the same words I used. Exemption is given to all 4 companies. You go further about commercial transactions, which is another query. But for this purpose, there also everything, all exemption is given. So, can you have a situation where because of the wording of the law, the relative is not allowed to hold shares in any of the associate companies? And if he holds, there is a problem there. I think, if you read all those provisions together, this is a fact situation where the judge has to feed in, applying the principles of harmonious construction is one, applying the principle of casus omissus is another, and say that you're also exempt, because it does not make sense that I am allowed to hold shares in the company and I cannot be allowed to hold the shares in the related entities. It does not make sense of that. This is a case of applying the omission and saying that the company should be widely interpreted to cover all entities. So that is how I think the answers to both the question is that you should be allowed up to 1 lakh rupees, that is 90,000 the figure given, you should be allowed. That should not be a problem. This is where, this and other places where institute could represent, and see that you clarify this, that why to remain out. Because you are talking of consequences, auditor may become disqualified. Not only that, you should clarify that who has to supply this, who has to comply this. Do all the partners, do the non-chartered accountant also apply with all these things? Because what may happen is sometimes, some relative may be doing certain things, you may not be doing. So either you make it clear, you don't want to allow, don't allow, but we are at least clear. Next question is about, it's a very common thing, if the question raises that a person, a partner of audit, again, I think the query is interesting, a partner, any partner is holding, is doing transactions with the company. So suppose take so many examples that there could be a listed company which is a very small. That is the example is given. So I or my relative, or rather I go to that particular mall. I don't even identify myself as the auditor. I go there, I buy the goods at the MRP. I pay by cash or credit card, whatever, and I come out. Does that disqualify me? Now, obviously not. And as rightly stated there, is that exemptions are given to all things done in the ordinary course of business and at arm's length, and by companies engaged in the business of telecommunication, airlines, hospitals, hotels, and such other similar business. So the first part is that can I carry out transactions? Yes, you can carry out so long as these conditions are satisfied. See, I have a fundamental question here also. The words used in the section are business relationship. Relationship does not mean if I go to, let's say, a particular mall and I buy a mobile or whatever, I am not entering into relationship with that person. I am not buying a transaction. Tomorrow I go there and buy another mobile for my wife. The third day I go and buy a mobile for my father. I have still not entered into a relationship. I might even take their, a point card which they are giving me. Still I am not entered into a relationship. Relationship is something more. Not doing one-off transactions, even if 10 times in a month. So that is another question which we have to deal with. But looking at this particular case, since the exemption is there, there should not be any problem. The question which is also raised is that, they have not specified malls and all that. But if you read, in the ordinary course of business, like companies engaged in the business of telecommunications, airlines, hospitals, hotels, now these are falling into various different categories. There is no underlying common pattern. All of them are giving goods and services to consumers. So therefore, such other similar businesses also should be very widely worded. Therefore, you go to a mall and buy some clothing or mobiles or whatever else. If they are supplying goods or services to consumers, this exemption should apply. Therefore, it should not disqualify.
Actually, to just continue on this, we had a very interesting session on almost same subject, and Sebi was answering this question. The transfer of resources. Transfer of resources is considered as a part of RPT related matters. Now, what is the intent and scope of the word transfer of resources? Transfer of resources could be, let us say, we both are company secretaries of 2 associated companies. My phone charge went off and I borrow his phone to make a phone call to my wife. And it means 1 rupee to be charged by other company secretaries' bill which is paid to the company to the extent transfer of resources. That could be one way of looking at it. Or I'm going to take a rented premises of that particular other company, it's transfer of resources. The transfer of resources are very far-reaching and hugely wide subject. Then SEBI answered the question saying that we will apply the context, we will apply the principle, we will apply the materiality and examine this issue, not broadly what you call interpretation. So rightly, let us say I am working, I am a director of a company which is also running hotels. I will go to stay there one night as a tourist or whatever. Will there be an association between us? Not really. Not really. It's not a relationship of that sense of the term. I think I agree with you. The question given to me. Mr. K is a political activist in the state of Jharkhand due to his political movement opposed to the ruling party in the state. He is made accused in many cases involving coercion, fraud, etc. In one such case, he has been convicted by the court of district magistrate and arrested for 22 days and got a bail. An appeal is made in High Court against the order of the lower court. It is pending for a year or so. In the meanwhile, K has been invited to join independent director of the board director. He is 164 attracted. I think that is very clear. The first sentence of this question is not relevant. Whether the political activist, whether the complaint against him is because of political vendetta, whatever it is. The point here is that he has been convicted. Law deals with only convictions. It does not deal with the background why he has been paid to the court. So long as he is convicted, yes, the rule kicks in. But then it's not clear from the question whether the conviction was more than 6 months or less than 6 months. If it is less than 6 months, he will get exemptions. If it is more than 6 months, irrespective of the fact whether it is a bail or not, he will be attracted to disqualification. You would have served for, let's say, conviction is for more than 1 year. He serves 15 days and then he has been granted a bail. Bail is not exonerating or reducing the punishment otherwise. He is able to, conviction still sticks to him. One thing is, he is not in jail, he is outside the jail. That's all the only difference is. And therefore, the answer is that if it is more than 6 months, he is attracting the disqualification. Being on bail is not of any relevance in this case. And therefore, he will be disqualified. The second thing is, what kind of precaution to take while certifying from DR12 upon how can one ensure that the companies in which the person is director has not fraud the company. I was a company secretary myself in some companies, and we used to take declaration for the director himself. That's the best way you can always believe, because he is the person who is supposed to say that I am working in so and so companies and none of the companies have actually defaulted. He will certify and give. I mean, in the stature of director, I don't think we can question him. Whatever he says, it's as an undertaking kind of truthful statement, we should take it as the first thing. Maybe its format of certification should be like saying that he should involve himself. Undertaking should be very strong. That's what the language should be. Reference to MCA site will be helpful. There will be information on defaults. RBI site may be helpful as for the NBFC section. That may give you. CIBIL may also give you some information about default made to the company. To the extent we can rely on these things. But I would say that director's declaration is the best what we call insurance for us.
But sir, whether CIBIL is not available to the general public, it may be available to the institution. Whether it is available to the any individual person, because okay, RBI, NCA, the place we can refer, but CIBIL I think it is not.
CIBIL we need, I think there's some paid services. Subscription.
One may have to subscribe.
Yeah.
That is actually maybe if you are taking a certificate from the director, we can ask the director to give the report. That is what our very common practice is. So maybe ask him to do it. Next question is on page 78. Question number 21. Again, a very interesting question. The question is, divided into many parts. Essentially, what the first part is that a statutory auditor has come across, one particular salesman in a particular, store of the company. He was giving wrong, information about the product, and he made them buy that product. And that is actually very common. Right? Now, what is the duty? So the auditor has come across this type of a situation. What is this? The first question is that are the auditors required to report such type of fraud? Then, further questions are given that suppose he has also stolen goods of 15 lakh rupees, then what should be done? Then what if he has stolen goods of amount of rupees 1,000 rupees? The amount was only 1,000 rupees. What is to be done? Then what happens if the management says that we are inquiring into it, we have not yet found a conclusion, then what should the auditor do? And finally, again more interesting question is that suppose these facts are come out not during the normal course of work, but you are doing a limited review of the accounts. In that case, what happens? Now here I want to go, because this situation is one of the most difficult areas for an auditor. The new requirement is that he is supposed to report a fraud directly to the central government in case of if he comes across a certain fraud. With that, just let me read out the new provision in the Companies Amendment Bill. What it unfortunately, if we were expecting that they will lay down what is the minimum amount. They have not yet laid down, they have just given an enabling power now. So if this bill is passed and it becomes an act, then the amount will be soon prescribed. How much time will it take? What I think Parasbhai was telling me that the bill has not yet been even laid before Parliament. So if it laid and then it get passed in both houses, it may take some time. So what is the minimum amount? Let's keep it reserved. Let us focus right now on what the law exists as of now. Now let us look at the relevant provisions of section 141(12). See, not all frauds are to be reported. I was talking with one of the other participants and he explained that Himanshu has already gone into a little bit detail. But I'll just repeat here that not all frauds are to be reported. And there are certain qualifications to that. First of all, it has to be a fraud. What is a fraud? We will come to later on. Then that it does not have to be a fraud maybe. It has to be an offense of fraud. So if you read section 447, it refers to fraud. Section 141 talks of offense of fraud. Now you have the why I want to emphasize the offense is that offense means the auditor has to have evidence or that there is an offense of fraud. An offense means a punishable. The point is that the bar, the benchmark, which is much more than something else. Because if you go to before a judge, if you want to prove a fraud, if you want to prove something else, under CD for example, if you have not filed certain documents, there is a Supreme Court decision in case of Shriram Mutual Fund says that the level of proof required is not much. If you have violated, there is everything is done. But if it is fraud, if it is an offense, then it has to be proved beyond reasonable doubt. Now I am not trying to say here that the auditor has to prove to himself. He should become in the position of a judge and prove himself that the offense is proved beyond reasonable doubt. But still I want to emphasize that it is not that suppose it comes out with a simple irregularity and he suspects a fraud, therefore he has to report. Because what we are doing is when you report a fraud, you are taking a lot of responsibility, holding a person and a company liable for fraud. So that portion is there. Then the next question is, of course, what is a fraud? This is also important. We do have guidance. If you read, for example, CARO 2003 Institute Standard, it defines fraud. It describes the fraud. Fraud, I'll read out. The term fraud refers to an intentional act. That is why I said, what is required, what is the difference between non-filing of a document. Shriram Mutual Fund Supreme Court decision said that if you don't file a document, mens rea does not have to be true. Intention does not, that is not relevant at all. You did not file, penalty automatically follows. But in case of fraud, there has to be an intention act. There is an intention act by one or more individuals amongst management, those charged with governance, employees or third parties involving the use of deception. There has to be a deception to obtain an unjust or illegal advantage. So what is understood as fraud is something very different from many other things. Fraud is there has to be an intention. Like to come to the second question, second part is what he has stolen goods. Now let's take an example. The cashier is there. He has got cash in his cash box, 15 lakh rupees cash. He runs away with the cash box. Is it a fraud? According to me, no. Theft is not a fraud. That person has not done anything deceptive. He just ran away. Some robbers come and they do. They have not done a fraud. So that type of thing, if it is purely a theft. But suppose that cashier comes back. He takes that, goes and keeps that 15 lakhs in his home. And here he accounts that 10 lakhs I give to X person, 5 lakhs I give to, so he falsifies the account. Then it is a fraud. So what has to be seen is, what has really happened in that particular case. The next 141(12) requires that it has to be against the company. Now here, if you read the question here, what it says is that this employee cheated the customer. Okay. So is that a fraud against the company? Here, again, I want to give a generic answer. It may depend upon the facts of the case. Why would he cheat the customer? Because he wants to, let's say, get commission. He has to do a performance, or he has to get commission from the company. If every day, whatever he sells, he will get certain commission. It means he is doing a fraud against the company also. But suppose he had done, if a person has just made some false statement to a customer in the generic course, then it may not be a fraud against the company. I'm just giving a broad guidance. In this particular case, I think it will be a fraud against the company also, because it would he is cheating the company because he is going beyond his job description. He is doing something which would hold the company liable, and more than that, he is trying to get some consideration from the company, maybe continuation of increments or commissions or whatever. So prima facie I would say that this type of fraud would have to be reported. Then there is one more condition. This fraud he should have come across in the course of his audit. Now in the course of his audit, you don't have come across all types of frauds. Suppose there is companies are doing quality fraud. And I think I read somewhere that 22 karat gold is sold as 18 karat. Now, if he comes to you as a consumer is one thing. If he has bought some jewelry from the company, goes somewhere else and finds out it's something else, that's one thing. But in the course of the audit, so that is another qualification. There are many qualifications. These have to be taken into account. So if he has stolen goods, the second part, then 15 lakhs rupees, purely theft of goods is not fraud unless it is something more has happened. If the stolen goods involved was 1,000 rupees, it doesn't matter. 500 rupees, 1,000. As of now, we don't have limits. The companies will say that they are going to specify limits up to which you report either to the audit committee if it is there or to the board of directors. And beyond that you report to the central government, but that has not yet come. As of today, there is no. Now the next question is that you have come out, found out this particular thing in your limited review of accounts, let's say quarterly accounts and the clause 41 of the listing agreement, you are doing your quarterly review and you found out that there is a fraud. Does it mean that you have to report this? Now section 141(12) as I said says that this fraud you should have come across in the course of audit. Section 141(12) is of the Act. So therefore the audit should be in the course of your audit under the Act obviously. But can you say that what you come across your limited review, the work you should do for your limited review is not part of your duties of your under the Act? It's very difficult because see, this is I see in practice that a person who comes for a quarterly audit, he is actually doing continuous audit. It's not that ex-partner comes for limited review, he does only that part, he keeps his audit note separate, and then for annual audit somebody else comes and he keeps his audit note separate, and these two people don't communicate. That's a very, very rare. If that is the very rare situation, then the answer could be different. But otherwise, and there also the question is that you are only auditing the name of the firm. But other than that, what you are doing a continuous audit. If you come across in the limited review, and see that you have to again see that if you come across a fraud that has happened, see the word used is committed, not suspected, not merely some contradiction you found which you have not gone to the logical conclusion. You have found a fraud in your limited review. According to me, the better we use that under 141 plan, you should. The next question is, I think it's a very generic question section, ABC and company. Now I'll read ABC and company as ABC and company limited. And that's it's a limited company obviously, otherwise the question should not be there. Is there a requirement of obtaining prior approval of the audit committee for such transactions? If no, then what are the steps required under the new Act? What if ABC and company is listed company as now what are the, see first of all ABC as related party transaction, is there a requirement of obtaining prior approval? If the company is of such size, of such nature like listed company, if under the Act if it is required to have audit committee, then it needs to take approval. Not direct, prior approval, but it needs to take approval under section 177(4) subclause 4. 177 refers to the scope of the audit committee which the board is to lay down. But one of the mandatory requirements of the scope of reference is approval of related party transactions. Then the words prior is not there. So maybe you can argue that prior approval, unlike listing agreement, prior word is not there. So. But I think as a practical measure, the approval always has to be prior. Can you go to audit committee and say I have already committed related transaction, now you approve, and suppose they don't approve. So as a good practice and an interpretation, you should take prior approval, but the section does not talk about that. Coming to the next part, if no, then what are the not steps? What are the steps required in the new Act? I think this would be redundant and it's too broad. Paper that what is the procedure required for under the new Act. What if ABC and company is a listed entity as regards the approval of the audit committee? I think that is also there in clause 49. Clause 49 specifically refers to prior approval, so you need to take prior approval. There are, omnibus provisions are there under the amended listing agreement, the second amendment, which came in September. And as per the company's bill, they also introduced a proviso that even for this section 177, omnibus advance approvals they are going to allow. But in what manner, that is what the rules will provide, that also once the Act comes.
I just want to supplement this. Is that approval is always prior approval. It is the interpretation given by full-time member of SEBI in a particular forum like this. The question came up saying that whether approval is a prior approval or post approval, what was the question? The answer given was exactly on the same lines as JNB said. Approval is approval, there is nothing like prior approval. That is, before you do the act, you should take approval. There is no point in saying, "Is भाई आपका घर में बहू लाया आप bless करो." तो वो तो आ गई ना, क्या करना? तो approval तो करना ही पड़ेगा. If approval is not done, what will happen? The both will get out of the house. That's why it's not happen. So prior approval has no meaning at all. Approval is approval, very clear, and therefore it always has to be prior. Is the interpretation given by SEBI, full-time member, not courts. And secondly, omnibus approval again was an interpretation or explanation given under the Listing 49. The omnibus approval would mean that in a routine basis, the related parties will keep doing transactions. For example, a related company is the only sole supplier of the component that is required by the other company in the whole of the country, and you can't get it from outside at all. So this is going to happen on a regular basis. Or for the purposes of this tax advantages, whatever, I create a company to provide me a particular spare part. And the routine is going to happen. In that case, you can have omnibus approval saying that during this year or during the next period of 3-4 years, I am going to take this kind of a component from my related party at so and so price. You can always take omnibus approval. Then you have to go back to audit committee for every transaction level. That's very clearly established now. The same omnibus approval interpretation given by listing agreement is coming into the act is what we believe, and therefore omnibus is a good thought that we can always consider. The only question that comes up, incidental question that comes up is whether audit committee is a executive committee or is a review committee. So long as so far it has been only a review committee, it is not an executive committee. But the moment you start talking about approvals, audit committee takes a view of executive committee. Therefore, a fundamental principle question comes in: the independent directors who are independent directors on the audit committee, will they continue to be independent directors or they become executive directors of the company? Is a broader question which nobody has so far raised in strict sense of the term. I feel that if it goes into Supreme Court, a constitutional issues can come up with this. That doesn't matter. But as far as we are concerned, audit committee approval is always a prior.
So just note one thing, since this is very practically important. The financial limit of omnibus approval is kept at a pathetic low amount of 1 crore. Would that not pose a practical problem? As you said, review, approve, and then review it every quarter. So it's virtually function of execution.
Yeah, I think the omnibus is the financial limit.
One crore.
There's no limit.
Omnibus approval can be of omnibus approval can be of any amount. But for more than that, even beyond omnibus, 1 crore is they can give.
That's what. It's a 1 crore is considered non-material for the purpose of this prior approval kind of thing. That's all. But otherwise, omnibus approval there is no financial limit at all. So the question number 11 is apparently tricky, but I think simple to answer. It says there is a hospital run by professional doctors, and professional doctors are also the management of the company. So what are the issues? Since they are looking after their own professional practice as well as they are not full-time directors, in that case, whether a company can pay remuneration to them, whether a company need to file returns under MR1 to 196, whether a company can appoint many of them as managing director even though he is having his own professional practice. And there is one opinion that the doctor should be appointed as executive director, though they are of understanding. There is no such concept of executive director in Companies Act 2013, whether the view is correct. But the written appointment will have to be filed if these directors are appointed executive directors. 196 is applicable only in case appointment of managing director, whole-time director, or manager. I think we should have clarity between terms of employment and the role of managing director, etc. There is no bar from the Companies Act perspective for a person doing more than 1 jobs. Okay, so he can be managing for your company and can still be doing portal waiter job if he feels in the evening. There is nothing, no bar on that from the Companies Act point of view. But the Companies Act, the company and the employment rules will say you cannot be in any other job. So long as you are working for my company, you cannot take any other job. It need not necessarily be at managing director level, it could be across any level. At any level, a person, as per the employment terms, he may be doing only that job, he may not be allowed to do any other job. That could be terms of employment and not a part of Companies Act provision. Therefore, any person who is an employee and a director is a whole-time director. Who is an employee and the director becomes full-time director. That's how the law says. Earning outside the job has no relevance to this provision. It could be term of employment contract. If you want to prevent that, you put a condition in your employment saying that you cannot do any other job and therefore preventing from doing practice if you want to. But as such, company that does not come in your way. It is true that there is no concept of executive director act, but ED is usually full-time director. If you look at the usage of the word executive director, the word independent director is there in place, and then people who are executives of the company, they are also directors of the board. They are getting called as executive directors, independent directors, executive directors, employee directors, non-employee directors, the various terms used. Executive director, in my understanding, will be a person who is an executive and also director of the board. That's how it should be looked at it. And there is no bar under the act or mandate doing the professional practice. There is no bar at all. Again, I am saying, if you want to prevent it, bring it as a part of the employment conditions. The next question is about the question number 12, which says 187C states limits of borrowing. Whether loan from directors will fall in this category, loan from directors will fall in this category. Exemption is given only to temporary loan from banks and ordinary course of business. So, in the given situation, majority of companies may have exceeded the limit of borrowing. This section was made effective from so and so, and is so. As on what date some private limited company had loans more than prescribed limit, does it have to pass resolution for the old loans, or is the resolution needed for future loans only? Lender is not relevant as far as borrowing limits is concerned. Lender, there is loan from director, maybe because of different reason you may have to take a different action, but as far as the limits is concerned, whoever is the lender doesn't really matter. We have to look at the amount as absolute amount. If the company has borrowed, 181C kicks in. That's what is important here. A narrow reading of the provision suggests that resolution is necessary only borrowing is proposed. If you look at that 187C, I have given it here below. To borrow money, when the money to be borrowed together with money already borrowed will exceed the agreement to do something. Therefore, the resolution is required when you propose to borrow, not when you already borrowed. So the question here is, for all the existing borrowings before the date of effectiveness of this particular act, if there are already some subsisting borrowings and whatever has been done, hopefully properly done, then no action is required now until you review them. That's my point.
Page 79 now. This is more than interesting. This is get another area and this is money creating a lot of difficulties. What the question raised is that in the context of private limited companies, what essentially the question is, I think to some extent was in an earlier question too, but here focused the question is that if a private company wants to enter into transactions and there is no real outside interest. In the question, one example has been given to make the point more clear, but the question is that if there is no real outside interest, should section 188 be applied? Of course, should, this is beyond our hands, good or bad, evil or nice, it is very much applicable. So this is where, we cannot do much except represent. So it should not be applicable to some extent, but here, we have to apply our mind a little more is that in case of private limited company also, there are people who are shareholders, there may be people who are shareholders who may not be in the controlling, they may not have, they would have less than 51% shareholding. Now, if the majority, they start entering into transactions which are, which are not in ordinary course of business or not at arm's length, the terms are bad, then they would suffer. Like, the example given is of PE investors. Now, if these companies tries to address their own, group at the cost of the minority shareholders, should that be allowed? So, this is the other side that, whether related party transaction should or should not be allowed. So, there are, both views, I mean, this is the common complaint, particularly, startup and all that. See, PE investors generally will try to have shareholders agreement or other structure where they will insist that certain approvals, their approval has to be taken. But other than that, the principle is that minority do need protection. Now the question here is raised is that in case of a group, let's say a private limited company is there in which there are 3 promoter groups, 50, 25, 15% respectively held by A, B and C promoter groups, and the remaining 10% is held by a PE investor. The question is, in that particular case, would if there is a particular related party transaction, would the other groups, so suppose if the related party transaction is with one of the members of A group, can the shareholders of B group, C group, and obviously PE investors of course will be eligible, but B and C group, they are promoters, they are not related with A group, but they are part of the promoter group. Can they be debarred from voting? Here, the circular of July, which has been given, is like most. Apart from that, even the rules and circulars are very ambiguous. But there they have said that in the context of that particular transaction, who is a related party, he should not be allowed to vote. Other people can vote. Under listing agreement, as we know, no related parties can vote. So if this was a listed company, it could have been created much more difficulty. Here it has been said in the context. Now, what does the meaning context mean? But I think looking at that, a circular has come out, and a circular has come out gives a relief. In that case, see, one of the questions which has been raised that in the context you mean all the related parties because it has not been specified. I think here it can be said that Group A should not be allowed to vote, Group B, Group C should be allowed to vote, and they and the PE investors should be able to decide. Here I want to still go that how people are giving opinions, how people are acting on opinions, and here again maybe Dr. Zab can maybe pitch on his own experiences. There is an actual case, I don't want to name it, it is there if you Google it. There is a transaction, there is a promoter group A, and promoter group A. The transaction was supposed to be entered with the Mr. A. His wife was also holding shares. Then there is of course promoter group B and C and whatever. But in case the transaction was with one Mr. A, his wife was holding shares. Can the wife vote? The opinion given was yes, she can give vote because what is prohibited is that with that particular related party, he should not vote. Everybody else should vote, including his wife. And that opinion has been acted on, and the votes were, and coincidentally, that particular group which was there, and I am talking about a listed company, so I am not even talking of private company. That particular listed company, in that one of the group companies had passed a similar resolution before this circular, and before the amendments to the listing agreement. Before that particular wife was not allowed to vote, they said no, this is a related party. After this, the wife voted at that particular thing, relying on an opinion that only that particular person who is a related party should not vote. So now as I said, there are various opinions. In this particular case, I will take a view that A as a group should not vote, B, C can vote, P investor of course can vote.
Just one supplement, not supplement, a view on the matter is that the related party transactions. There's a lot of regulatory ambition, if I would say, in drafting it out at both the NCA level and the SEBI level. They have written English without understanding what in English would mean finally in the practicing world. That's a real problem in there. And therefore, I agree with Jayadbhai's interpretation when you have got three groups within promoters ABC group. If A is found to be related, B and C can vote. Let it be challenged in court of law. Until then, I don't think the regulator will understand what they have written and what the principle is exactly. This is I'm sorry to say that, but this is a reality of life because they are written without understanding, without drawing a chart about what it means, where all it will reach. We had a situation, I tell you, slightly out of the way, but I'll do that. Stockbrokers should give information about their associates, and the associates they have got to any extent. Then Goldman Sachs or Merrill Lynch has some broking company in this country, and they had to give me about 6 to 8 pages of names of the companies related to them. And we wanted shareholding pattern, managing director, KMPs of all that. 6 to 8 pages of list of names they had to give, and imaginary like the disclosure they are going to make, and what am I going to do with that? If all the information get what will I do? Then we went back and told SEBI saying that you are asking the associate as a too big a bird. How do you restrict it? Then they said, okay, let's stop with the only the broking company in this country. That is, there are a lot of enthusiastic MBAs in the regulator's office. They write this English. So we have to wait for interpretations to come.
Okay. question 24 on page 18. What the question raised is essentially is that two examples are given, that under the old law, under the new law. Under the old law, the useful life of asset number 1 was 20 years. Under the new law, it is 10 years. In this particular case number 1, the asset has already been used for 12 years, and there is a WDV given of 4.50 crores. Now the question is, what do you do in the current year? That's 2014-15. Now, note 7 of Schedule 2 deals with this particular situation specifically. It says, it says that if you have a situation, and it deals with situation 2 also, that in that particular case, same 20 years was the useful life in the earlier law, 10 years is the useful years now, and now 8, in this particular case, 8 years life has already gone, 2 years life more is there. Now what do you do? In case of 1, the useful life is already over. You already used asset which useful life under the new law was 10 years, now you already used for 12 years. So it means useful life is here. What Schedule 2 says, note number 7b, it says that in that particular case, now see that this particular schedule was amended, recently. Earlier, what Schedule 2, that particular note referred to was that you shall adjust this particular amount as against the opening balance of the reserves and surplus. So this is, the retained earnings, that was the word used. So 4.50 crores shall be adjusted against the balance, the opening balance of accumulated earnings. Now the amended Schedule 2, that particular note says, it may be adjusted. So it means you have got an option to adjust against the accumulated earnings as on 31st March 2014. The question is, suppose you decide, what you don't want to adjust. In that case, what do you do? Can you say that, okay, I'm out of it, can I depreciate over the remaining period? I don't think that is the intention. The intention, and if you read along with ES6, accounting standard depreciation. Accounting standard depreciation does not deal specifically with this situation. So finally we have to interpret 7b only. But it does say that, if you have got accumulated depreciation of this particular type, then you should write off during the year. So I think finally the two choices are, you adjust against the opening earnings, so you don't want to take a hit in the current year's accounts. Then you may adjust, so you do adjust. Alternatively, if you don't do adjust, you have to adjust in this particular year. I will also rely on, Companies Bill 2014, the wording, just in a related case, they are proposing to amend section 123, and they want to introduce a third proviso, which I will read out. Provided that no company shall declare dividend unless carried over previous losses and depreciation not provided in previous years or years are set off against profit of the company of this particular year. So again, the intention is that don't have any accumulated thing, write off in this current year. So of course, this is only for declaration of dividend, and the context is also different. But I think taking all these three things together, you cannot say that the words may gives me option not to adjust altogether. You will have to adjust one way or the other. The second point is that you have got 2 years of life, so that again, note number 70 is very clear. What you have to do is, now you have to write off this particular remaining amount over the 2 years.
Yeah. This is question number 19. It is a very tricky question. What it says is that as on 31st March 2014, expenses has paid share capital of 100 crores, security claim 40 crores, P&L account, turnover, etc. There are so many events given here, so many items given here. And please guide as to what could the problems in the new act, advise the companies as to steps to be taken immediately. It requires reading of so many items. I think it comes.
Already granting has been over.
I think it's a 38, sorry. I'll take it later on.
It's question number 38.
38, sorry. 38, we'll go to the question number 13. It's not 13. Corporate social responsibility. 32. Sorry, question number is 32. For the purpose of requirement of company for CSR, profit means profit before tax or after tax for the last 3 years. Wordings are not clear. On the basis of the question, I closely read this. See explanation to section 135. Explanation to 135. It says it refers to section 198.5. And 198.5 clearly says tax is not to be deducted, and therefore profit means for the purpose of CSR profit before tax. It may be very harsh interpretation, you may not like it, but I think it seems to be the reality because they are referred to 198.5. Because 195 explanation says that. And then ABC Limited are subsidiaries of ABC Limited. A Limited, B Limited and C Limited are subsidiaries of ABC Limited. ABC Limited has formed a group CSR policy for all subsidiaries to follow. Can the holding company carry out the CSR project while the subsidiary companies contribute their share to the same by making the payment to holding company? Read Rule 4.3 of CSR rules. It very clearly says that there could be a group policy and group CSR activity, but each company must be able to place a report on CSR activity in the prescribed format. The format in which they are about to place it, which gives the amount spent, benefit to them, etc., etc. So therefore, holding companies should share transparently all the information with the subsidiary companies, and subsidiary company must be able to place a report for CSR. As such, there is no bar in participation of subsidiary companies or say group companies participating at a group level of the CSR activities. There is no bar at all on this. When you read the Rule 4.3, all this is evident.
We are on page 80 now. Question number 25. This is a very interesting question and would have some far-reaching implications. And very well drafted in the summary. The situation which is given is very, I will remain focused on the situation only because there can be so many variants of this particular table. But the good example which is given is that here is the situation where company Y is holding shares in the share capital of the company X. The company X has got two categories of capital. One is equity share capital and one is convertible preference share capital. And then there is a total capital. Company Y is holding 60% of the equity share capital of company X. Company Y is holding 10% of the convertible preference share of company X. Therefore, if you take in the terms of overall capital holding, it is 43.23% of the total capital is held by company Y and company X. The question which is raised is this company X a subsidiary of company Y under the 1956 Act, under the 2013 Act, under AS 21? And let me deal with 56 Act and AS 21 first. I think the law is very clear, and that is what probably the intention of the queries to highlight is that under the 1956 Act, the requirement is that how much capital do you own of the equity share capital, what is the nominal capital. And in this particular case, it is very clear you are holding more than 50%. Therefore, under the 1956 Act, yes, you are a subsidiary. Under AS 21, similar wording is that if you are holding more than 50% of the equity share capital, you become a subsidiary. AS 21 also is. 213 Act, intentionally or otherwise, they have taken a different term. They have said that you will count the total capital, that is not the total capital, but the equity share capital plus the convertible preference share capital, and see whether that particular company, that is why in this particular case, does it hold more than 50% of the total capital of equity and convertible preference shares. Here in this case, on the face of it, the company does not hold. So there are two conditions. One of the conditions is that you should be holding more than 50% of that particular capital. Therefore, that condition does not apply. So you are not a subsidiary under that condition, that particular condition. But that, I think the answer does not end there. You look at the second condition. The second condition says that if you are controlling the composition of the board of directors of the other company. Now, if you go back to the history of the Act, this particular provision has seen various amendments, control the composition. Because earlier, if you go to little back even further, this was heavily misused to create a subsidiary and to get over section 370 and 372 because they used to exempt subsidiaries. So what people used to do was, they used to form a company, hold 10% or so, whatever was permissible under a maximum limit up to 370, 372. Then they used to enter into an agreement with that particular company and ensure that agreement is incorporated in the articles of association of the company. And they used to say that under that agreement and articles, our company, our board will control the composition of your company's board. So immediately, as per that second rule, they become a subsidiary. Once it became the subsidiary, it was exempt under section 370 and 372. So they people went ahead and invested as much as they want without complying the requirements of the provision. I think at that time even central government's approval. So then they amended. That matter went to courts. Court said yes, this structure is very much valid. Now you could question that whether court should have seen through that the whole thing is a sham. But what you lay down in the articles of association, if that particular board is agreeing to allow another company to control the composition of board of directors, they pay their token. Whatever it is that was used, abused, misused, whatever. Therefore the law got amended, saying that if this particular you cannot have a subsidy under 372, which is through the control of composition board. In that case, section 370 is not exempt. So that is the history of that particular section. Now what has also happened, I mean, the story is always 2 steps ahead of the police. What they started doing was using preference share capital, convertible preference share capital, and therefore they used to have more than they used to hold in such a way that they used to hold more than 50% of the capital there, and at the same time equity share capital was little less, or the other way around. So that these provisions were also misused to allow. And see, we have to understand this, that this abuse was there. So what we are facing, 185, 186, 188 and all that, we are talking about harshness, but there is a background to it. There has been so much abuse. So if we don't look at that and say that we are facing harshness, then Sahara and so many other things we should discuss in Sahara and all that, they have heavily misused the concept of deposit, convertible debentures and so on. Whatever it is, so today the situation is, that is the history. But the words controls the composition of board of directors. If I am holding more than 50%, in this particular case the table says I am holding more than 60%. Do I control the composition of the directors of X? The answer is according to me yes. That once I hold more than 50% of the equity share capital, I control the composition of that, and therefore it is a subsidiary. And I will cite 2 case laws for this, which deal specifically with this particular situation. One is Delhi High Court decision in the case of Oriental Industrial Investment Corporation. It is of 1981, 51 company cases, 487. There is one more decision of the Kerala High Court, Velayudan versus Registrar, 1980, 50 company cases, page 33.
Say again, sir.
Velayudan, 50 company cases, page 33. Velayudan M versus Registrar. I'll read out a couple of sentences from that, from Delhi High Court decision. Control over the composition of the subsidiaries board is almost invariably derived from the voting rights derived by the holding company by virtue of shares in the subsidiary held by its nominees, but it could also arise from the subsidiary memorandum of articles. So what it said is, if you control more than 50% of the capital, then you are controlling the composition. If you are not holding, then you would go to the articles. In this particular case, you are already holding more than 50%. Therefore, you are controlling the composition. So under the second condition, you become a subsidiary. Therefore, finally, my answer is that in all the 3 situations, that X is a subsidiary of company Y. Coming to, I think section 26 is already been dealt with by Anup Shah. He has put a whole period of question is that what are the advantages of LLP, whether it is permitted, not permitted, what are the advantages, what are the disadvantages of firm versus LLP. There has been a whole paper and I put by the organizers that we need not go into spend time on that.
This is a very interesting question, scientific philosophical question. A listed company is in the process of formulating its CSR policy, making CSR committee and yet to commence its activities. The company accountant wishes to know whether in quarterly financial results, proportionate provision should be made for CSR expenses yet to be incurred by the company. It's a prudential answer. I'll tell you, we have to understand a concept called as comply or explain. This particular 135 concept has been brought into the comply or explain process. I'll tell you why. Provided the company fails to spend such amount, the board shall, in its report under clause so and so, specify reasons for not spending the amount. That is, a company may not be able to spend is foreseen by the provision and says that the directors in their report have to say why they could not spend the money. If you take a view that company may not spend the money in that year for whatever reasons and they have got an explanation to give to the public at large, including MCA, etc., then it is possible that you may not spend and therefore no provision is required. But it is a fair amount of certainty that the CSR activity has been initiated, some trust has been entrusted, some activity has been initiated, but money is yet to be disbursed. You are very able to clearly foresee it for the purposes of, from the listed company, for the purpose of creating a true and fair view of the accounts, you may want to make a provision. But in consultation with the management, if you are very clear that you are not going to spend this money during this year, since provision is there available for explaining away why you could not spend, you don't have to make a provision. I don't know whether I am communicating to you. It's a question of there's no penalty for not spending. There's no punishment for not spending. There's no other action to be taken in case not spent. What all is required is only to explain to the world that I could not spend this money. So therefore, comply or explain is the consequence of this particular principle. When it's only a question of comply or explain, then is provision required? Strictly speaking, not required. But if there are policies being formulated and schemes are being drawn up, amount is likely to be incurred in any case, if that's what accountants view is, then as a prudential entity may provide this expenditure. Monthly 5, provision, second provision is important to understand. Yeah. No, company fails to spend such amount. Fails to spend the amount, what happens then? Why are they making provision? If I have to definitely spend the money, I have to provide it. If I am failing to provide, what will happen? What is the consequence? The consequence I have to explain, that's all. Nothing else is provided in this.
No, that's right. It says spending. So once I'm not spending, you shouldn't make a provision on it.
No, that's what I'm saying. You don't have to make a provision if there is a clarity in your mind at the management level that you are not going to spend money this year. You are part of the question. The listed company is a process of formulating CSR policy, making CSR committee. Nothing is happening still. The next 6 months they are going to do all this. Policy is not yet made. Team is not selected. Nothing is happening. Therefore, prospects of spending is not there. If there is no prospect of spending, will it be, as Yedbhai said in another question, what are the consequences of not spending? Consequences of spending, not spending, let us say directly to send to a jail. Then better take a provision and say, demonstrate